Major lawsuit going on in the state of Minnesota over whether or not 18 to 20-year-old American citizens have the right to carry guns outside the home for self-defense, which is required by the Supreme Court's decision in NYSRPA V BRUEN. But several gun rights groups are fighting this case against the state of Minnesota. Stay tuned, learn the details. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, member of the U.S. Supreme Court Bar, best-selling author, and most importantly, proud American gun owner. And if you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms, and feel free to share this video far and wide. Okay folks, so the state of Minnesota bans 18 to 20-year-old American citizens from being able to carry guns. Minnesota, by the way, is a shall issue permitting state, which means that if you meet a basic objective criteria, you're allowed to carry guns in the state of Minnesota, but you have to be at least 21 years of age to be allowed under the permitting system to carry firearms. Now, we have the NYSRPA V BRUEN case that says it's a constitutional fundamental right to be allowed to bear arms, which means carry firearms outside the home in public for self-defense. There is a lawsuit pending in the district court, the federal district court in Minnesota, brought by 3 gun rights organizations and multiple individuals who are between the ages of 18 and 20 and want to be able to carry firearms and qualify for the shall issue regime, but the state of Minnesota's law doesn't permit them, so they're challenging the law. The 3 organizations are the Second Amendment Foundation, the Firearms Policy Coalition, and the Minnesota Gun Owners Caucus. Those are the 3 gun rights groups, and then there's 3 plaintiffs on top of that, I believe. Now, we've talked a lot about the importance of making sure that 18 to 20-year-old gun owners are allowed to have their full Second Amendment rights. There was a major victory we talked about here about a month ago before NYSRPA V BRUEN, where the Ninth Circuit Court of Appeals in California actually said that 18 to 20-year-olds do indeed have Second Amendment rights to keep and bear arms, just like all other American citizens. And I think this is clearly the case, and I think if the Supreme Court ever has to deal with the 18 to 20-year-old issue, they're going to rule in favor of the 18 to 20-year-old gun owners. So let's just go through some of the basic reasons why 18 to 20-year-olds have a right to keep and bear arms and have a right to, of course, qualify for shall issue or otherwise carry firearms outside the home for self-defense. First of all, let's just read the Second Amendment, right? The Second Amendment says the right of the people to keep and bear arms shall not be infringed. Well, who are the people? Well, the people are American citizens. Certainly at a minimum, it's everyone that's 18 years of age or above. Why do we say this? Well, just common sense. Americans view 18-year-olds as adults, right? They can enter into contracts. They can voluntarily join the military. They can get married. They can be compelled to serve on jury for jury service. They can be drafted, conscripted. Among other things, they are full-blown adults. So, and of course, if they commit a violent crime, they can, be tried as an adult and sentenced as an adult. Once they hit 18, they're no longer juveniles. So why is there so clearly under the people definition of the First Amendment, 18 to 20-year-olds are part of the people. Remember, when the United States Constitution and our founding fathers wanted to draw some sort of an age-based distinction in some way, they actually wrote it into the Constitution. Just think about it for 1 second. In the United States Constitution, it specifically says that before you are allowed to run for Congress, meaning for the House of Representatives, you have to be at least 25 years of age. It's actually written into the Constitution. No such limitation exists for the Second Amendment or any aspect of the Bill of Rights for that matter. Moreover, if you want to be the President of the United States, you have to be at least 35 years of age. Again, there is no age limitations in the Second Amendment's right to keep and bear arms, unlike for running for president or the House. So when the founding fathers wanted to limit the ability of younger folks to be able to do something within the context of our constitutional system, they actually wrote it in there. But again, there is no age limitations at all when it comes to the Second Amendment. That's the first thing. Second of all, the text clearly says the people, which encompasses, I would say, anybody that's an adult, which include 18-year-olds. Again, we know that the text of the Constitution makes it clear if they want to draw distinctions between age groups, they do that. But beyond that, let's look at the specific history of the Second Amendment. Remember, the Second Amendment and the entire Bill of Rights, the first 10 amendments, is ratified, approved, gone into effect in the year 1791. Now, why is 1791 important? That was the year of the first Congress that served. And what else did that first Congress do in addition to ratifying the Bill of Rights, including the Second Amendment? Well, that exact same body, these exact same men in the first Congress also did something as well just a few months after ratifying the Second Amendment. They adopted the Militia Acts of 1792. And what did the Militia Acts of 1792 say? Well, the Militia Acts of 1792 specifically said that all able-bodied males, it specifically referred to white males then, between the ages of, I think, 18 and 45 were in the militia. So, and mind you, what this meant is that meant 18, 19, and 20-year-olds were clearly contemplated as individuals who were permitted, allowed to have firearms in all respects. Because remember the way it worked back then in the 18th century, that the firearms, ammunition, and weaponry that you owned for your day-to-day use at home is exactly the kinds of arms that you were responsible for bringing. In fact, you were actually required to bring from your home to militia service. Okay, so think about that for a second. Not only were there no bans at the time of our founding on 18, 19, and 20-year-old American citizens from being allowed to possess firearms or carry firearms, if anything, what the law said was that these 18, 19, and 20-year-olds actually were required to own these firearms and this ammunition and the black powder and the cartridges, etc., because they needed to own these so they could bring them to militia duty under the Militia Acts of 1792, a law enacted by the first Congress, which was the exact same Congress that adopted and ratified the Second Amendment's right to keep and bear arms. So to somehow argue, as the anti-gunners will try to do in the state of Minnesota, that 18 to 20 years have no constitutional right to be allowed to carry guns, well, under the NYSRPA V BRUEN case, the only way the state of Minnesota can prove that case is that they can demonstrate a historically analogous law in 1792 or 1791 at the time of our founding, that showing that 18, 19, and 20 years weren't allowed to have guns. Guess what? They're not going to be able to do it. Moreover, although I think this is a cherry on top of the sundae, because I think that the case at this point is a slam dunk given NYSRPA versus BRUEN, that 18 to 20 years will be entitled to full-blown fundamental constitutional rights to keep and bear arms. I do want to give you this quote from George Washington. This is from a 1783 letter that George Washington, the father of our country, wrote. I'll put the quote down below in the description because it's authenticated, it's real, you can run with it, it's very powerful. It was written in 1783, obviously several years before the Second Amendment, but it shows the mindset of 18 to 20-year-olds and where they were going. This is what Washington wrote. Now, who did Washington write this letter to? Oh, to another founding father by the name of Alexander Hamilton. So George Washington is writing this letter to Alexander Hamilton about 18, 19, and 20-year-olds in the militia and bearing arms. This is what Washington wrote. Quote, "The citizens of America from 18 to 50 years of age should be born on the militia rolls." That's right. So in 1783, George Washington literally is talking about 18, 19, and 20-year-olds being in the militia when he writes to Alexander Hamilton. And as we know, one of the reasons why you have a Second Amendment is to make sure that the Americans always had the right to private firearms for many reasons, one of which was so they would have arms as they were needed to bring those privately owned firearms and ammunition and weapons to militia service to help protect the country from various forms of tyranny, everything from criminals, foreign invasion, domestic insurrections, whatever it was. But the point is that this lawsuit brought against the state of Minnesota, which has a law that says 18, 19, 20 years are not allowed to carry firearms in public. They do not qualify under the shall issue legal regime for carriage of firearms in Minnesota. It looks to me this should be a slam dunk case in favor of the plaintiffs. If I were the state of Minnesota, I would think long and hard about maybe settling this case and just saying, look, you got us, nothing we can do. But of course, that's not how anti-gunners think. They want to force you and the Second Amendment community to spend as much time and money as possible to fight for our Second Amendment rights. And I'm sure the state of Minnesota is going to be doing the same yet again on this case. But ultimately, I suspect they're going to get their butts kicked. And thank God for that. Okay, I hope you learned a little bit something about 18 to 20-year-olds in the Second Amendment. If you haven't subscribed to the channel, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.